friends, welcome to the Point. In this session, let's discuss about the basic structure of Indian Constitution. Let's discuss why there was a need or emergence of the basic structure in our Constitution. A question arises whether the fundamental rights it can be amended by the Parliament under Article 368 or not, which came for the consideration in the Supreme Court. And in the Shankari Prasad case in 1951, the constitutional validity of the First Amendment Act 1951, it curtailed the right to property. The right to property was challenged in Shankari Prasad case, which was a fundamental right in the year 1951. The Supreme Court ruled that the power of the Parliament to amend the Constitution under Article 368, it also includes the power to amend the fundamental rights. The word law in Article 13 means that only ordinary laws and not the Constitutional Amendment Acts. Therefore, the Parliament can abridge or it can take away any of the fundamental rights by enacting a Constitutional Amendment Act, and such a law will not be void under Article 13. But in Golaknath case in 1967, the Supreme Court reversed its earlier stand. The Supreme Court ruled that the fundamental rights that are given are transcendental and immutable, and hence the Parliament cannot take away any of these rights. For this judgment in Golaknath case, the Parliament reacted to the Supreme Court's judgment in Golaknath case by enacting the 24th Amendment Act 1971, and this act amended Article 13 and 368, and it declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. And Supreme Court overruled its judgment again in the Keshavananda Bharati case in 1973. It upheld the validity of 24th Constitutional Amendment Act 1971 and stated that Parliament is empowered to take away any of the fundamental rights. And at that time, it laid down a new doctrine for basic structure of the Constitution. It ruled that the constituent power of the Parliament under Article 368, it does not enable it to alter the basic structure of the Constitution. The doctrine of this basic structure, it was reaffirmed and applied by the Supreme Court in the Indira Nehru Gandhi case in 1975. In this case, the Supreme Court invalidated a provision of 39th Amendment Act 1975, and this act it kept the election disputes involving the Prime Minister and the Speaker of the Lok Sabha outside the jurisdiction of all the courts. Again, the Parliament reacted to this judicially innovated doctrine of basic structure by enacting the 42nd Amendment Act 1976. And this 42nd Amendment Act 1976 in Article 368 and declared that there is no limitations on the constituent power of the Parliament and no amendment can be questioned in any court on any grounds, including the contravention of any of the fundamental rights. Supreme Court, again in the Minerva Mills case, invalidated the provision that excluded the judicial review, which is a basic feature of our Constitution. Applying the doctrine of basic structure with respect to Article 368, the court said that the Constitution had conferred a limited amending power on the Parliament, and the Parliament it cannot exercise its power more than its limited power. The Parliament under Article 368 it cannot expend its amending power so as to require for itself the right to repeal or abrogate the constitution or destroy its basic features. Again in Varman Rao case in 1981, the Supreme Court adhered to doctrine of basic structure and it further clarified that it would apply its constitutional amendment enacted after April 24, 1973. This is the date of judgment of Keshwananda Bharati case. Elements of the basic structure. The present position is that the Parliament under Article 368, it can amend any part of the Constitution including the fundamental rights, but without affecting the basic structure of our Constitution. The Supreme Court is yet to define or clarify what is the basic structure of the Constitution. From various judgments, some of the basic features have been emerged. They are supremacy of the Constitution, sovereign, democratic and republican nature of the Indian polity, secular character of the Constitution, separation of powers between the legislature and the executive and the judiciary. We know that legislative, executive and judiciary have their own powers. Federal character of the Constitution, that is central government or union government and the state government. Unity and integrity of the nation. Welfare state or socio-economic justice. The welfare state is a form of government in which the state protects and promotes the economic and social well-being of the citizens based upon the principle of equal opportunity, equitable distribution of wealth and public responsibility for the citizens unable to avail themselves of the minimal provisions for a good life. Judicial review. Judicial review, it is a process under which executive or legislative actions they are subject to review by the judiciary, that is by the courts. Freedom and dignity of the individual. What is dignity of an individual? Dignity is the right of a person to be valued and respected for their own sake and to be treated ethically. Parliamentary system. The parliamentary system or parliamentary democracy, it is a system of democratic governance of a state where the executive derives its democratic legitimacy from its ability to command the confidence of legislature, typically a parliament, and is also held accountable to that parliament. Rule of law. Rule of law is a principle that all people and institutions are subject to and accountable to law that is fairly applied and enforced. The principle of government by law. Harmony and balance between fundamental rights and directive principles of state policy. It can be concluded by saying that the basic feature of our Constitution is to maintain a harmony between fundamental rights and directive principles of state policy. They are complementary and supplementary to each other. The theme of the fundamental rights must be made in light to directive principles of state policy. Principle of equality. The right to equality is the right of all human beings to be equal in dignity, to be treated with respect and consideration, and to participate on all equal basis with others in any area of economic, social, political, cultural, or civil life. Free and fair elections. The most fundamental principle which defines credible election is that they must reflect the free expression of the will of the people. To achieve this, election should be transparent, inclusive, and accountable, and there must be equitable opportunities to compete in the elections. Independence of judiciary. Judicial independence, it is a concept that the judiciary should be independent from the other branches of government. That is, courts should not be subject to improper influence from the other branches of the government or from private or partisan interest. Limited power of the Parliament to amend the Constitution. Parliament, it has a limited power to amend the Constitution. The Parliament cannot damage the basic structure of our Constitution, and Article 368, it does not provide the power to the Parliament regarding the amendment in Part 3 of the Constitution. The Parliament, by amending Article 368, it cannot increase its amendment powers also. Effective access to justice. Access to justice is more than improving an individual's access to the courts or guaranteeing legal representation. Article 238, that is access to justice, it is defined as the ability of the people to seek and obtain a remedy through a formal or informal institutions of justice for grievances 284 in compliance with the human rights standards. Principles or essence underlying fundamental rights. 7 fundamental rights were originally provided by the Constitution. They are the right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property, and right to constitutional remedies. And right to property, it was deleted by the 42nd Amendment Act. Powers of the Supreme Court under Article 32, 136, 141 and 142. Under Article 32 of the Constitution of India, it confers power on the Supreme Court to issue the direction or order or writ, including writs in nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari. Article 136. The Constitution of India, under Article 136, it says that the Supreme Court of India is the apex court of the country, with a special power to grant a special leave to appeal against any judgment or order or decrees in any matter or cause that is passed by any court or tribunal in the territory of India. Article 141, it provides that the law declared by the Supreme Court, it shall be binding on all courts within the territory of India. And finally, Article 142, it allows the Supreme Court to pass any order that is necessary to do complete justice in any case. Powers of the High Courts under Article 226 and 227. Under Article 226 of the Constitution, the High Court it has the power to issue not only the writs of certiorari, prohibition and mandamus, but also other writs, directions and orders. Powers of High Court under Article 227 of the Constitution, it confers on every High Court the power of superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction, excepting any court or tribunal constituted under any law which is relating to the armed forces. See you in the next session with some other interesting topic. Thank you.